My name is Aviva Gordon. So what is estate planning? Estate planning is a meaningful and intentional process whereby while you are alive, you set up what happens for after you are not alive. Your estate is essentially all of the assets that you own or you have an interest in, and you create, in theory, and if you do it right, and if you listen to me or other smart lawyers, you create a plan that ensures that there is meaningful transfer of those assets upon your passing. What are the possibilities for estate planning? You can make no plan at all and your assets will still pass upon your passing. You can have a will, you can have a trust, or you can have a comprehensive plan with a trust, pour over will, and powers of attorney. The benefits of a comprehensive estate plan meaning a trust, pour over will, and powers of attorney, is that you have control. You create a meaningful pathway for what happens when you either are unable to control your assets or when you have passed. You avoid probate, the swarming of the lawyers around your family's ship in the ocean, and the uncertainty and the time and the money associated with that. With comprehensive estate planning, you can protect your beneficiaries, sometimes even protecting them against themselves. I have 3 children. They're marvelous and amazing and special and spectacular, and if you don't believe me, you can ask them because they will tell you all of those things. And thus far, they have made really good decisions because their dad and I are alive to make sure that they don't make stupid decisions. But if we are not here, and if, for example, my 18-year-old son were to become involved with a young woman who is really not the right young woman for him, she would perhaps not be his forever wife, but maybe his today wife. We want to protect whatever it is that we are passing to our son away from unwise choices. Similarly, in the absence of comprehensive estate planning, so this is in the absence of a trust, upon the passing of my children's parents, since all of my children are over 18, they would get their interest right now, today. Let me talk about my 18-year-old boy again. He will buy a stupid car. It will be stupidly expensive and stupidly fast. Within 6 months, he will stupidly wreck it. And then for the rest of his life, he will not have what we had planned out for him to have. So having comprehensive and meaningful estate planning protects him from getting too much money too soon, and also protects him against the creditors that may be out there for him or against him. Also, a comprehensive estate planning also prevents family disputes. I have 2 sisters, older sisters, which means I am the baby in case anybody hasn't already figured that out, and I always get my way. At least that's what they think. So when my mom passed away, we could have gone a couple of different ways. We could have fought over everything. And I have seen this. I have seen the fights over, it doesn't matter if there is monetary value to it. I'm going to fight over that envelope that has that piece of paper in it that means nothing to anybody and certainly doesn't have any value, monetary value to it, because it's what I want and because my mom didn't properly say, this goes in this direction, this goes in this direction, this goes in this direction. And if you are leaving people behind you, the last thing that you want is the people that you love to fight with each other over your things. Comprehensive estate planning will prevent that from happening. What is probate and why do we want to avoid it? Probate is a judicial process. By that I mean that a judge makes decisions. Person with the black robe, who depended upon whether that person with the black robe ate cornflakes or Rice Krispies before that person took the bench, will make those decisions based upon the cornflakes or the Rice Krispies. And there will be lawyers that are involved. The probate process in Nevada is public, which is to say all of those assets that you have acquired, that you have thought were private, that you have made efforts at keeping private, at making sure that your former brother-in-law doesn't know where the secret stash is, all of that becomes public because it's in a judicial filing. There is public notice to all potential heirs and creditors. Let me talk about potential heirs. That would be that nephew of yours that you hate. That nephew of yours that you hate would have the ability then to make a claim in the probate for assets that you wanted to have go to somebody else. There is the appointment of an executor or administrator. Executor is if there is a will, administrator is if you do not have a will. And that is somebody who is not you, who makes decisions and makes recommendations to the court about where assets should go, and ultimately pushes those assets in the direction that the court orders. There is a public inventory and appraisal of assets. Let's talk about appraisals. Let's talk about not necessarily just appraisals of real estate, but appraisals of personal property. Time-consuming, expensive, uncertain, and, 3 different appraisals can come up with 4 different numbers, right? There's time and money and uncertainty associated with that. During the probate process, the payment of all allowed debts and taxes will get paid. Even if you have the best estate planning in the world, which I hope that you all will have either currently or you will have into the future, taxes have to get paid regardless. We'll talk in a few minutes about some other issues with respect to taxes. Taxes always get paid, right? And for the most part, your final expenses and known creditors at the time of your passing get paid as well through a probate. So whatever that amount that is owed on your Discover card, that'll get paid through the probate. And then after all of those things have been paid off, and most importantly, after the lawyers have been paid, then and only then will there be distribution to family members or those that are entitled to receive anything from the estate. Intestate, which is if you die without any will at all, right? And an intestacy probate will then charge the court to find your heirs. And there is a process that follows the degrees of consanguinity, which just means blood relations, right? So a spouse receives, and then assuming that there's no spouse, then the court looks up, down, and side to side. Parents, children, siblings. If you have a brother that you don't like, he still gets to participate and get some of your assets. If you're no longer speaking to one of your parents, that parent gets to participate and receive assets. And it is also a time-consuming process. Also in this jurisdiction, the costs associated with it are a percentage of the gross value of your estate. Not the net value, the gross value. If you own a home and your home is valued at $500,000, but you've got a $490,000 mortgage on it, we don't talk about the equity. It is a percentage of the gross value of the estates. And that is what's charged against your estate before there is distribution to your beneficiaries. What about wills? It's one step ahead. And as I told my dear friend Emily earlier today, August, which starts far too soon, is National Make-A-Will Month. If you don't have a will, get a will. If you have a will and nothing else, it is not enough. A will still require for you to go through probate. And if you have heirs or beneficiaries that are 18 or older, they will receive their distributions outright at 18. Let me remind you about my son and his hypothetical Ferrari, right? I would much rather see him in a Prius, in case you're curious. So it is one step above intestacy, or one step above not having a will, still not enough. And we already talked to some extent about some of the fees. There are court filing fees, There are attorney's fees, which also can either be on an hourly basis or a percentage of the gross, right? So reasonable attorney's fees are allowed to be charged. So reasonable is a gray, mushy kind of word, right? Now, in terms of the percentages of the gross, to the extent that those are required, yes, that is statutorily based, and they're breakpoints based upon the value of the estate. So that part is within the statute, as I never recommend anybody to go through intestacy. I cannot tell you what those are, because if you leave here thinking that is your plan, Devin, then we need to have a more serious talk about a lot of things. Executor fees, those are all strike that. Those are not statutory based. Those are based upon what the court says are reasonable fees for an executor. So what an executor can do is sit back on his or her laurels and still get paid, or be a more active executor as well. It really is within the court's discretion as to what those fees should be, unless they are outlined in documents such as a trust or a will. And appraisal fees, which we have already talked about. So let's say you've got $100,000 that you want to pass on to, say, oh, I don't know, Jane. You want Jane to be your beneficiary. You're welcome. You want Jane to be the beneficiary, and you've got $100,000, and you say, you know what? When I die, Jane's collecting $100,000. Not so fast. Jane is not collecting $100,000. Subtract the court fees, subtract the attorney's fees, subtract the executor fees, subtract the appraisal fees. Suddenly, Jane's getting about $60,000, and she's having to wait about 18 months for that. Now, say that the $100,000 that you intended for Jane was so that Jane could, do what was necessary to secure a kidney, which I think is not legal to pay for it, but let's humor me for a second on that, right? If Jane's waiting on a kidney and needs $100,000 to pay for the kidney and has to wait another 18 to 24 months, that probably is not the way you wanted to have it under any circumstance, right? So these results do not sufficiently control what you want for them to do. They do not provide for you meaningful passage of your assets onto whomever it is that you want to have as your beneficiaries. Probate takes, as we said, about 18 to 24 months, assuming there's no dispute. So, anybody remember Tony Hsieh? No, Tony Hsieh died without a will? Know that Tony Hsieh died, I think, in 2021. Do you know that there is still ongoing litigation of Tony Hsieh's assets? Want to know how much the lawyers have made so far from the Tony Hsieh estate? Millions of dollars. Still not done. Still no end in sight. In Clark County in Southern Nevada, we have one probate commissioner. So that is the probate commissioner who deals with probate for all the people that die in Clark County. One person who's a public employee who, oftentimes doesn't work on Friday afternoons and other things along those lines, and is under no sort of urgency to act. And if there are disputes, right, the attorney's fees that I just talked about will multiply exponentially. So Jane's $100,000 suddenly becomes $5,000 because Kobe disputed it. Because Kobe came in and said, it's not what we meant. Jane's not really entitled to that because of whatever sort of legal basis. And not only that, not only are there reasons to challenge and dispute it, but Kobe's also going to claim that he is entitled to recover attorney's fees out of that process. Don't feed the beast. Don't pay the lawyers unless you absolutely have to. So we're moving on to trusts. And let me talk about what a trust is. A trust on its face is a methodology for controlling how it is that your assets transfer upon certain triggers, primarily your death, but not exclusively. A trust, at least when we create them, it's about this thick, right? it's a big, thick pile of documents, but it's so much more than that. It is the expression of your wishes and how things will proceed once you are no longer in control of your assets. So it will provide for your spouse if you have a spouse. It will provide for your children if you have children and want to include them. You also have the ability, so long as you do it right, of specifically excluding those people. Let me talk about my 3 kids again. One of them has just sucked the life right out of me. I'm not going to give her anything. Just kidding. But I could make that decision. I could say, you know, nope, I've done enough. I'm not doing any more. I have to be specific with that language and make sure that I do it appropriately, but I can do that. But I can also have other triggers for when my children receive things. We already talked about my son who's 18. 18-year-olds make very, very bad decisions. For my kids, at least, and I think this is true for Kobe and Jane's kids, if we drafted it correctly, there are age triggers when they receive pieces of their inheritance, because the decisions that an 18-year-old makes are wildly different from the decisions that a 25-year-old makes, that are wildly different from the decisions that a 30-year-old makes, and wildly different from the decisions that a 35-year-old makes. So, at least with us, and our recommendation for our clients is you are deliberate with when your heirs receive certain things. We also make sure that even if there are those triggers, to the extent that somebody needs something for their health, education, maintenance, that those are always there for them, assuming that there are funds that are in the estate for those purposes. And we also have limitations, right? Creditors cannot, my time's up, bye. While the assets are in the trust, creditors can't collect against it. And we'll talk about that in a minute with respect to irrevocable trusts as well. Beyond that, if a trust is written well, it will also have language for special needs. So to the extent that there is an heir or beneficiary, and you don't know this because you don't have a crystal ball, but you don't want to have outright distributions that would preclude them from being able to receive government benefits. So if the trust is written correctly, you are not going to asset preclude those individuals from the ability to have government benefits should they need government benefits. The hallmark of a revocable trust is that it can be revoked. You can change it. So long as you are alive and competent, you can change anything about it at any time while you are alive and competent. Now, revocable trusts, if they are created correctly and funded correctly, if you put your assets into the trust, for my realtor friends, that is a transfer of your real estate into the name of the trust. For all of my friends, that is a transfer of your bank accounts, your investment accounts. If you have business interests, all of those go into the trust. That nice stack of paper that I just talked about is 100% useless if you do not fund it, if you do not transfer assets into it. But you can change things. You can do whatever it is that you need to do, and you can avoid probate through the use of a revocable trust. A revocable trust, however, for the grantor, for the person who writes it and creates it, does nothing for asset protection. Let me say that one more time because people think that it does provide asset protection, and it does not. It does provide asset protection for those who come behind you, your children, your beneficiaries, other people that aren't you, right? An irrevocable trust is a trust that you cannot revoke, that you can make very, very, very limited changes to it, depending on if it's written properly. Here are the amazing things about irrevocable trust, in Nevada in particular. It's a great state, isn't it? Don't we live in the best state? Yes. Not only do we live in the best state because, well, we're all here, right? So where else would be great? But because Nevada Asset Protection Trusts are the finest asset protection trusts in the nation and probably internationally as well. A Nevada Asset Protection Trust does, if you do it right, provide complete asset protection from creditors. Nevada Asset Protection Trusts still allow for you as the person who creates the trust to have some access to it. There have to be protections in that, so it's really outside of your control. But there are so many levers that can be pulled that essentially you can get most of the things that you want out of your irrevocable trust without ever allowing for creditors to touch those assets. What makes Nevada Asset Protection Trusts unique and special is it has the shortest period of time to sort of bubble wrap your assets within the irrevocable trust, within the asset protection trust. The second thing is it provides complete asset protection against creditors. That would include former spouses. That would include errant children. That would include the government. So to the extent that there are any reasons to have concerns about protection of assets, Nevada Asset Protection Trusts are really the finest that are available. And we live here so you all can qualify for them. The other thing that irrevocable trusts can do, and I hope this becomes a problem for each and every one of you, and that it helps to alleviate the challenge with estate taxes. So right now, the estate tax threshold or exemption is at about 28 or 29 million. I went to law school because they promised me there would be no math, so I give sort of iffy numbers. There are cost of living and inflation numbers that get kicked into that, which is why it's a little bit mushy. It's a big number. At the end of 2025, that gets cut in half. Depending upon, and I am not having a political conversation today or any day, but depending upon what happens with different policies and different political viewpoints, that number can get lower and lower over time. In addition to that, the estate tax rate, now understand, this is based on assets that you've already paid taxes on. The estate tax rate is 40%. Nevada irrevocable trusts, and actually all irrevocable trusts, have the ability to pull those assets out of your estate such that when they pass, estate tax is not triggered. I think you paid the government once, you probably don't want to pay the government again, and you probably want all the value of the assets to go forward to your heirs and beneficiaries.